Today is March the 18th, 2024. It's 10 o'clock a.m. I'm going to call the meeting of the State Ethics Commission to order. Looks like we've got 13 matters on the agenda. Has everyone had an opportunity to review the agenda? All right, I'm going to take that as a yes. Are there any changes to the agenda as presented? I don't hear any there. I'm going to go ahead and make a motion to adopt the agenda. Got a second?
Second.
Got a motion and a second. Any comment? Call the question. All in favor say aye. Aye. Any opposed? All right. So it looks like number 2 on the agenda is a special recognition that we would like to have this morning. It was about 2 weeks ago, I believe, I received one of those telephone calls that you never really want to get. It was from then Commissioner Darrell Hicks advising that he was going to be stepping down from the commission. I've absolutely enjoyed working with you with everything that we've done, and I'm glad to say that we have adopted in procedure what we have all referred to as the Hicks rule. And so what I will say is that at least for my remaining time on the commission, I will always continue to refer to that as the Hicks rule. So I'm going to turn it over, excuse me, if anyone else has any comments. I think that Mr. Amati may have some comments for you.
Thank you, Mr. Chairman. And I'll start by saying, first of all, the chairman stole my joke about the Hicks rule. That was, credit where it's due. No, I remember when Mr. Hicks was appointed to the commission, was down speaking at a caucus retreat, and I was surrounded by a few friends who were like, "Oh, so you got a new commissioner?" And I said, "Did I now?" And they said, "Yeah, Darrell Hicks." I said, "Okay, if you say so." And they said, "No, really, the governor's office appointed Darrell Hicks to your board." To which I looked over at one of the governor's aides who was at this meeting and said, "A heads up would have been nice." But in all seriousness, Darrell, you've been just wonderful to work with. If for nothing else, the Hicks rule will have improved the efficiency of this board. And just thank you for your service and best of luck moving forward.
If no one else has anything in that regard, Darrell, we're going to ask you to come forward. We're going to take a photograph, and I've got something to present to you, certificate of recognition. We hereby present Darrell Hicks with this certificate acknowledging your service to the State Ethics Commission, August 17, 2021 through February 29, 2024.
Thank you, sir. Appreciate it.
Let's go ahead,
David, thank you. Yep. David.
Okay.
Can I get a copy of that? That'd be great.
Hey, well,
Yeah,
we
we appreciate
appreciate
it. Thank you very much.
Yeah, we should make sure that you do all your signs.
Just have a T-shirt with that.
I was going to say
Good
that.
luck, sir. All right. Thank you all.
Thank you, Darrell.
No, we're not going to accept, I don't know if this is any fine.
That's what I just told him, to make sure those are correct. Okay, we're going to go ahead and move to item number 3 on the agenda. It's review and approval of the meeting minutes for December the 8th of 2023. Again, has everyone had an opportunity to review those minutes from our last meeting? Again, I'll take that as a yes. Do I have any questions, comments with regard to those minutes? All right, hearing none, I'll go ahead and make a motion. I'll move that we go ahead and approve the meeting minutes for the December 8th, 2023 regular commission meeting in Savannah.
Second.
Got a motion and a second. All in favor say aye. Aye. No one opposed. All right, we're moving right along. We're going to go to item number 4 on the agenda, which is preliminary hearings. The first one we're going to call is case number 22-0023-C. It's in the matter of Brad Barnes, and it's my understanding that this is going to be Mr. Cusack. Is that right?
That's correct.
Do we have that on?
Yes.
Oh,
We did have Mr. Barnes joining via Zoom.
you need to start putting that on here.
I thought you were confused about something, but
We just use this.
All right, Commissioners, this is in the matter of Brad Barnes. This is case number 22-0023-C. I believe Mr. Barnes is joining via Zoom. Mr. Barnes, can you hear us? Maybe
Hold on.
he did.
I've got him muted, hold on.
Okay, we'll unmute him.
Can you ask him again?
Mr. Barnes, are you there?
He's not responding, but he's off mute.
He's off mute. Okay, well, I'll go ahead and get started then. Mr. Barnes ran twice in 2020 and 2022. He ran for State House District 13. He was the unsuccessful candidate in both elections, and once candidates qualify for office, they have 15 days to file a personal financial disclosure statement. So this case centers on the failure to file a personal financial disclosure statement in 2020 and 2022. And from looking at qualifying this past year, he's not on the ballot in 2024. So these centered on the last two election cycles prior to this one. This complaint was filed on March 28th of 2022. It alleged a failure to file a personal financial disclosure statement within 15 days of qualifying in both of those election cycles. Since he was an unsuccessful candidate, he wouldn't have owed one for 2021 or 2023, so it just centers on these 2 years where he was an unsuccessful candidate. I spoke to Mr. Barnes. The first complaint the first PFDS was on our old system, the legacy e-filing system, and the second complaint, the second allegation centers on the new e-filing system. And I actually helped him get an account.
Sorry, I'm sorry. Technical difficulties. Now I know I'm curious.
Mr. Barnes, can you hear us now?
Yes, yes.
Okay.
We were both wondering if something was wrong with our setup because we didn't hear anything.
Gosh, did you hear what I was saying before, or?
No, that's the first thing I heard from you.
Just go ahead and start it again.
Okay, I'll go ahead and start over. All right, Mr. Barnes, this case is in the matter of Brad Barnes 22-0023-C. Mr. Barnes.
Yes.
Just give me 1 second.
Okay.
I think you're right.
Zoom always makes things more fun.
Yes, there we go. Now we're working again. All right, and Mr. Barnes ran for the State House District 13 in 2020 and 2022, where he was an unsuccessful candidate. And the allegations are that he failed to file a personal financial disclosure statement in 2020 and 2022. This complaint was issued on March 28th of 2022 and alleged failure to file these PFDSs within 15 days of qualifying for both of those elections. Spoke to Mr. Barnes when this complaint was issued, helped him establish an account on our e-filing system, the new e-filing system, which was new at the time of the 2022 election cycle, and ultimately we were able to get his PFDS filed after the complaint had already been issued. So there's one now. It was just filed after the complaint was issued. This is the legacy e-filing system where Mr. Barnes established an account, or the e-filing account, and you can see there for the electronically submitted reports there was no PFDS for that time period. And then in 2022, here is the actual PFDS which was filed. This was filed on March 30th of 2022. So he would have had until March 26th to file that. And the complaint was initiated on March 28th of 2022. And then after being served, Mr. Barnes was able to file this personal financial disclosure with some help from the commission. So the allegations here are that these weren't filed. The first one just hasn't been filed. This one was filed after the commission helped them through it, but since it was filed after the complaint was initiated, we've always counted that as not being filed and punished that as not being filed. There's some possible mitigation after the fact if we were to work out a consent order with this getting filed so quickly in time after the complaint was issued. But I haven't spoken to Mr. Barnes since we talked about this case initially, so we'll see. Maybe there's an opportunity to work this out 30 days after finding the probable cause is found. But we can always see what Mr. Barnes has to say in his defense today. So with that being said, I'll turn it over to Mr. Barnes if he has anything to offer to the commission, or if there's any questions from any commissioners, I'll take those.
Yeah, hold on one second, Mr. Barnes. So the two alleged violations that are set forth in the packet, those are remained unchanged even if any filings later occur. Is that
Correct.
right? So we're still talking about 2019 and 2021.
Yes, it would be calendar year 2019, 2021.
Right. Okay. Mr. Barnes?
Yes, sir. So the 2020 was accepted in paper form by the lady at the window. So when I went down to qualify, I came over to the commission to file the paperwork there. If you remember, that was essentially as everything was starting to shut down for COVID. And so I have the commission's seal on that paperwork. You know, I think I actually had sent a copy to your attorney, the fellow that had previously spoke, as well, showing that the commission had put their seal on it and accepted it.
Is there, I mean, Mr. Cusack, do you have any record of receiving anything like that?
So I don't know. I certainly didn't receive it, but also it's statutorily assigned for the state house or any state office that they have to file online. We can't accept a paper filing. You can come to our office and drop stuff off, but it's a requirement in statute that you file it online, all state level candidates or public officials.
Commissioner Thompson?
Yeah, that was gonna be my question. I'm confused about exactly what he has that has the seal on it. And if he can't, I mean, he needs to provide a copy to us because I've never heard of us having a seal. Do we even have a seal?
No. We have a file stamp of when something's accepted,
Yeah,
but
so
it's.
I didn't know what this is referencing, so I'm confused here.
Yeah,
Have you ever seen the document he's referring to?
I have not.
Mr. Barnes, do you have the document that you're referring to?
I think I might have a scanned copy here, if you'll give me just a moment to go in here, ethics forms, personal financial disclosure. Let's see. Okay. This is 2020, yeah. Yeah, so I can screen share that, and let's see, this is the notarized commission copy from 4 in 2020. Let's see, there's 2 copies here. Let's see which one is. Okay, here we go. Yeah. Let me share my screen, and I can show you the scanned PDF.
Mr. Barnes, I don't know if
where
that's
is that in the interface.
It may be something that you just need to email to Mr. Cusack. So,
I can certainly do that as well, and I at least recall that I had done so, but you know, it's possible, you know, with the volume he gets, it got lost
31st, 2022 CCDR. Those things did not occur. They were never filed. I had communication with him back on June 8th, 2023 and discussed these matters. And subsequently spoke with them on or about November 2nd of 2023. However, since that date, I've not been able to reach him despite repeated emails and made several phone call attempts. As I stated before, he's required to file the non-election year CCDRs pursuant to 21-534 C1B. This is the DOI that he filed back on February 8th, 2022, and these are the filings that were in Athens, Clark County, essentially showing that he did not have any CCDRs filed in 2022 whatsoever. These were exhibits that were actually provided by the third-party complainant, just in showing that he did have an election page at the time when the original complaint was filed, seeking to receive contributions. There were some t-shirts that he had, so there appears to be some expenditures. And again, some additional advertising from Mr. Dorsey's campaign website. Additionally, there was a billboard truck that was used. So again, these are just showing there were clearly some expenditures, but nothing had been filed. This CCDR, Mr. Dorsey filed after the complaint. He received the complaint, and I discussed this with him, advised him what he needs to file, and so he did file his June 2023 CCDR, so he was in compliance at that point. Showed some expenditures, but essentially that's what this case is. It's not overly complicated. He simply didn't file the two CCDRs for June 30th and December 31st, 2022.
First, before we go to any questions from the commissioners, is anyone here on behalf of Mr. Dorsey today? No one on Zoom, is that right?
No one, sir.
Okay. Any questions for Mr. Knittel? Commissioner Thompson?
So he has filed a June 30th, 2022.
Yes, sir.
Has he filed a December 31st, 2022?
So since that time, he's filed an affidavit where he's not going to exceed $2,500 in expenditures.
Okay. Have we verified that he hasn't, did he report more than that?
He did not. He had, in his filing that he had reported $500 and then I believe $600, so $1,100.
In contributions and expenditures?
Yes, sir.
And have we verified that since we're already going through the complaint process? Because some of the pictures you showed looks like maybe it's possibly more than $2,500.
So short answer is no,
Okay.
but not through lack of attempting to verify that. He's been non-responsive.
Okay.
So.
And I guess this will be the same situation that we were in with one of the hearings down in Savannah, which is that if we end up, even if we find reasonable cause with regard to, these two alleged violations, that doesn't stop us in any way from going back and actually making additional charges if further information is found.
That is correct.
Yeah. Okay. Any other questions or comments from any of the commissioners? All right, I'll go ahead and I'll make a motion that we find that that Mr. Dorsey, that there are reasonable grounds that Mr. Dorsey violated OCGA 21-5-34C1B as a result of not filing his CCDRs on June 30th of 2022. Is that right?
Yes, sir.
Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, that one passes. I'm also going to make a motion that we find that on December 31st of 2022 for non-election year CCDR in violation, that Mr. Dorsey is in violation of OCGA 21-5-34C1B. Do I have a second?
Second.
Got a motion and a second. Mr. Thompson for discussion.
So he filed the affidavit that was dated When was the affidavit dated?
Let me go back.
Because when I asked you, did he file the December 31st, 2022, you said no because he filed an affidavit.
And Commissioner Thompson, I do not have that readily available in my PowerPoint. I know it was after you filed the CCDR, but before December. I can look it up and I just don't have it right in front of
It
me.
was before, what December? Not before December 2022.
No, it was before December 2023. I just don't have the date readily at hand. I did not include that in here, but I know that they filed it.
a year mixed up.
Okay. No,
I think he meant to say he filed the affidavit in 23.
okay.
He filed the affidavit in 23 after he filed the June 30th, 2023 CCDR. Does that make sense?
Yes.
And before December 2023. If you could, I can make sure you're aware of the date once I look at my notes again.
We've got a motion and a second. Again, is there any further discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right, that one is granted as well. Anything else with regard to this case, Mr. Canoe?
No, sir.
Okay. Is Mr. Cusack back yet? Oh, I'm sorry, I didn't, I was looking back behind you. All right, I'm gonna go ahead and call again for preliminary hearings, subsection A, which is 22-0023 in the matter of Brad Barnes. Mr. Cusack, do you have any additional comment with regard to that case?
Yes, and Mr. Chairman, I just need a little guidance on how we want to go about this. So we've reached a consent order, but it's orally. I don't have a consent order to present. Would you like to continue it to the next calendar, and then I'll get it to Mr. Barnes, and I'll bring that back in front of the commission at the next meeting?
Yeah, I don't have any problems with continuing it for the consent orders. You know, this is gonna be the same thing that I said about some of these others. You know, if it's not resolved before then, it's gonna be on the preliminary hearing part of the calendar, we're gonna hear it.
Right.
All right. I'll go ahead and I'll make a motion that we go ahead and continue case number 22-0023, which is in the matter of Brad Barnes. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? Okay, Mr. Barnes, we'll give you the opportunity to work this out with Mr. Cusack, but if it's not worked out, by the time of our next meeting, which is gonna be in June, it will be on the preliminary hearing calendar, okay?
Right. So were you able to get also a copy of that disclosure?
Yes, and that wouldn't be part of the consent order like we discussed.
Okay.
Yeah.
Okay, anything further, Mr. Barnes?
And Mr. Barnes, I'll email you and with the consent order and let you know what's going on with everything.
Okay, sounds good.
Thank you, Mr. Barnes.
Thank you.
All right, we're going to go ahead and move on to item number 5 on the agenda. This is the consent orders. It looks like, Mr. Cusack, you have the first two, which are items A and B.
And Commissioners, I just will give the quick synopsis of these two consent orders here. 20-0002-C is in the matter of James Sells. Mr. Sells served on the Grantville City Council. He was actually the mayor before he served on City Council, but he was in public office a number of years. This was a third-party complaint which was filed by Selma P. Cody on January 16th of 2020. The lapse in time was due. Mr. Sells hadn't received the complaint. He has a couple of different, he's a real estate investor, so I think he gets a lot of mail, he said. So once he was actually noticed at this hearing, got him the complaint, we were able to work this out. But what the complaint alleged is that on his PFDS, his personal financial disclosure statement, he failed to list certain properties that he owned as an investor. He said, I forgot to do that. You know, these were investment properties. I listed my home address. So there was a amount of investment properties that he owned that he did not list on that. Right when he received notice of the hearing, he reached out. He was able to fix what he had. He's not in public office anymore. He has no desire to serve in public office anymore. He told me, he said he will never be holding public office again in the rest of his life.
Has he spoken to Mr. Hicks about it?
Yes, maybe too. So taking all that into consideration, he's agreed to a $250 civil penalty in this matter.
All right, next.
Next is in the matter of Gregory Adams. It's 23-0019-C. Mr. Adams was a candidate for the DeKalb County Commission during the 2018 and 2020 election. He actually served on the DeKalb County Commission prior to these elections. But this was part of our DeKalb County audit, and Mr. Adams failed to file 2 campaign contribution disclosure reports. He's very cooperative in this matter. He turned over documents via subpoena before they were due. Worked diligent with me to get this matter resolved, and so he is paying $250 in late fees for the violations in this matter. And then he has since filed those reports and then terminated the account. So he is up to date on everything, in compliance, and he wanted to make sure he was in compliance before this was handled. So that was Mr. Adams. And that concludes my consent orders for this meeting.
Looks like Mr. Bagwell, you're next.
Yes, sir.
Item C through item I.
Position C, Tasha Allen, case number 24-0025. Ms. Allen is a current candidate for Clayton County Commissioner. This was a third-party complaint that we received. The allegation was she didn't file a non-election year CCDR. She agreed that she was in violation, the statutory section 21534 C1B. She agreed to pay a $125 late fee, $125 civil penalty, total penalty of $250. Position D, Donald Mitchell, case 21-0034. He's a current member of the Alpharetta City Council. This was a, excuse me, this was a third-party complaint that we received. The allegation was he twice filed late his PFDSs, violation of OCGA 21550A for calendar year 2020 and calendar year 2022. He agreed to pay $250 in late fees for a total penalty of $250. Position E, Larry Savage, case 24-0010. He was an unsuccessful candidate for Cobb County Commission Chairman back in the 2020 election cycle. He had one violation of OCGA 21534 C2A. He failed to file an election year CCDR. He agreed upon payment of $125 late fee, $125 civil penalty, for a total penalty of $250. Position F, Deborah Jones Bazemore. This is case 24-0022. She's a current member on the Georgia House of Representatives. She had 2 violations of OCGA 21550 subsection A. She failed to file calendar year 2021 and 2022 PFDSs. She agreed upon payment of $250 in late fees, $250 in civil penalties, for a total penalty of $500. Position G, Julia Hurtado. This is complaint 24-0019. She was an unsuccessful candidate for Cobb County Board of Education back in 2020. She had one violation of OCGA 21534 C2A for failing to file an election year CCDR. She also had one violation for pre-DOI spending in the amount of $116.16, a violation of OCGA 21530 subsection G. She agreed to pay $125 in late fees, $250 in civil penalties, for a total penalty of $375. Position H, Nicholas Simpson, complaint 24-0012. Mr. Simpson is present today. Does not want to speak. He just came to observe the work that the commission does. But I did talk to him before the meeting. He is here. He was an unsuccessful candidate for Cobb County Clerk of Superior Court back in 2020. He had 2 violations of OCGA 21-5-34 C2A. He failed to file 2 election year CCDRs. He agreed upon payment of $250 in late fees, $125 civil penalty, for a total penalty of $375. Position I, Ronald Harbin. This is complaint 24-0017. He is a current member of the Enigma City Council. This was a third-party complaint that we received. He was alleged to have violated OCGA 21-5-50A. He failed to file his calendar year 2021 and 2022 PFDSs. He agreed upon payment of $250 in late fees for a total penalty of $250. And that concludes my consent orders today.
Thank you, Mr. Baywall.
Thank you, sir.
Looks like next up is Mr. McCarter, is that right? Excuse me. It looks like it's item J through the end, item S.
Yep. So we'll start with item J, in the matter of Chris Stansel, 23-0046-C. This arose out of the Pickens County audit that our office did. Respondent currently serves as the County Commission Chairman of Pickens County after winning the seat in the 2020 election. In this matter, he failed to file campaign disclosure reports within applicable time periods. It was through 2017 through the present. Upon receiving the complaint, Mr. Stansel was very cooperative. He contacted the commission right away and admitted his mistake and his failure to file those reports. In total, we agreed to pay a $500 penalty to the commission. And our next is in the matter of Carlotta Harrell, 23-0049-C. This matter came to us by a third-party complaint by Tina Correa. And the respondent currently serves as the chairwoman of the Henry County Board of Commissioners, which she was elected in 2020. And in this matter, she failed to file personal financial disclosure statements for the years of 2019, 2021, and 2022. And also, in addition, failed to file a total of 9 campaign contribution disclosure reports within applicable time periods from 2019 to the present. And we agreed that a total penalty of $2,400 would be sufficient for this matter to resolve this matter. She's very cooperative, admitted her mistakes, a great person to work with. Next is in the matter of Awanyula Deli Loman, 23-0054-C. This matter came to the Ethics Commission by a third-party complaint from Cheryl B. Moore Mathis, which I believe was her campaign manager or worked on her campaign in some capacity. Respondent was a candidate for the office of the mayor of Stonecrest, Georgia during the 2023 election year. In this matter, she failed to file her personal financial disclosure statement outside the time constraints provided by the Campaign Finance Act. I spoke with Ms. Lohman, and there was a bunch of confusion going back and forth between local filing officers and what she believed she had to, the timeline in which she was supposed to file things. But she completely admitted that she had failed to file this personal financial disclosure statement. We agreed that a $125 fine was reasonable in this matter. And next is in the matter of Sabria Hakeem Hill, 23-0064-C. This matter came before the State Ethics Commission, a third-party complaint by Tina Correa. Respondent currently serves as the Clerk of Superior Court of Henry County, Georgia. In this matter, the respondent failed to file her personal financial disclosure statement covering the calendar year of 2019. Respondent explained that there was some confusion surrounding what year needed to be covered for the personal financial disclosure statement. She was confused that it had to be the prior year, not just the current year in which she was running. Respondent also failed to file 5 campaign contribution disclosure reports from 2020 to 2023. In resolving this matter, we agreed that a total fine of $750 would be reasonable to resolve this claim. The next is 24-001-C in the matter of Richie Mason. And this matter arose out of our Cobb County audit. Respondent ran as a candidate for the office of chairman of the Cobb County Commission in the 2020 election cycle. The respondent failed to file campaign disclosure reports within the applicable filing periods. He failed to file his January 31st, 2020 and December 31st, 2020 campaign contribution disclosure reports. I will take a second. Mr. Mason was very cooperative, almost following up excessively, getting me everything I needed. So we agreed that a total fine of $125 would be appropriate in this case. And next is in the matter of John Cristodoro, 24-0018-C. And this matter arose out of our Cobb County audit, and respondent was a candidate for post 5 of the Cobb County Board of Education in Cobb County, or is a candidate, he's currently a candidate for that position. Respondent improperly accepted campaign contribution prior to filing his declaration of intent. Respondent had previously filed a DOI with our office, but he was confused that he had to file it with his local office before it would take effect. Upon receiving the complaint, the respondent was very cooperative with me, explained his confusion, and promised not to let it happen again. We agreed that a total penalty of $250 would be appropriate to resolve this matter. Next is in the matter of Jade Terraberry, 23-0051-C. This matter came before the Ethics Commission pursuant to a complaint filed by Gregory Vanden Hurel. Respondent was a candidate for Roswell City Council post-war during the 2023 election year. In this matter, respondent accepted a campaign contribution in the form of a personal loan from Mr. Lee Hills in order to pay her qualifying fee to run for office on August 25th, 2023. 6 days later, respondent filed her declaration of intent with the city clerk's office. Upon receiving this complaint, respondent was again very cooperative and admitted that she was just unaware that she couldn't accept a loan from somebody before she had filed her declaration of intent. In resolving this matter, we agreed that $200 in penalties would be appropriate in resolving this. Next is in the matter of Charlie Bibb, 23-0063-C. This matter came before the Ethics Commission pursuant to a complaint filed by us. Respondent serves as a city council member of the city of Warren Robins, Georgia, as he won re-election to the seat last year in 2023. In the present matter, respondent filed his personal financial disclosure statement. However, it was discovered that the respondent had not disclosed his ownership interest in real property. Further, Mr. Bibb failed to file 4 campaign contribution disclosure reports from 2022 to 2023. Upon receiving this complaint, Mr. Bibb was really very cooperative, admitting his mistakes, and thought that he didn't have to keep listing his real property interests for his house every single year. He thought if he did it once on one report, he didn't have to do it through the years. In resolving this matter, we came to the agreement of $500 in penalties would be sufficient to resolve the case. Next is in the matter of Vicki Benson, 24-0007-C. The respondent was a candidate for post 1 of the Cobb County Board of Education in Cobb County, Georgia. And in this matter, the respondent failed to file her June 30th, 2021 campaign contribution disclosure report on time. Respondent also failed to file supplemental reports as she carried a balance after her campaign. She believed her campaign to be ended, the campaign account hadn't been brought down to zero, so she needed to keep filing those supplemental reports. And Respondent was very cooperative in getting me everything that I needed and assured me that everything would be corrected and that she would file those supplemental reports. We agreed that a $250 penalty would suffice in resolving this matter. Next is in the matter of Leroy Hutchins, 24-0006-C. This arose out of our Cobb County audit. The respondent served as a member of, or currently serves as a Board of Education for Cobb County for post 3 Cobb County. He won election in 2020, and in this matter, respondent failed to file his personal financial disclosure statement for the year 2020, or excuse me, he filed his personal financial disclosure statement for the year 2020. However, it was filed late in violation 21-5-50. Respondent also failed to file his campaign contribution disclosure report for June 30th, 2021. Upon receiving this complaint, respondent informed me that he had already paid the late fees associated with these allegations, so we were able to, I was able to confirm that from the receipts that he provided to me, and he paid a total of $250 in fees. And I believe that covers every, oh my.
For, excuse me, for all three of you gentlemen, do we have signed consent orders in place currently?
Yes, and all of my consent orders have been paid, all the fines have been paid and everything, so.
Okay. Excuse me, other than Mr. Simpson, is there anyone else here present with regard to any of the consent orders that were just commented upon that want to say anything here today? All right, we are, I do have two comments first. First, it sounds like, cooperation goes a long way with what's happening here. So, I guess if it's noticed to any candidates or public office holders, anything like that, they should recognize, how well the staff works with them, and they really, it goes a long way to provide support with y'all. So I wanted to mention that first. And second, this is a question for all commission members, staff, anyone else. Have we ever had a member of a candidate's own staff file a third-party complaint against them? Okay, I found that as a very, very interesting part of this. So
I think we have.
Yeah, we have.
Really?
Yeah, we did.
Failure to pay them.
Yeah.
Over vendor
Yeah.
issues.
wow. All right. So any other comment or anything with regard to the commissioners about any one of the cases that we just went over? All right, I'm going to go ahead and apply the Hicks rule, and we'll go ahead and make a single motion that all of the consent orders commented upon by staff be approved. I've got a motion. Any second? I'll second it. I've got a motion and a second. Is there any discussion? No discussion. I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right. So all the consent orders are approved. Again, I want to thank the staff for all of your diligent work in being able to work those out. Item 6 on the agenda, those are administrative dismissals. I believe the way that we've been handling them most recent is that we will give the commissioners any opportunity they may have to address any of the administrative dismissals. I believe that Mr. Amati wants to go ahead and make a comment.
Yeah, and clarifying what you said, Mr. Chairman, these matters are dismissed upon my signature. But if any of the commissioners have any questions, we can remove them individually, or we can even reopen the case if there's some need to. We've done that in the past, but that's the procedural posture.
And I do know that there is no vote or anything like that that's taken with regard to these administrative dismissals. But again, do any of the commissioners have any questions, comments, or what have you for Mr. Amati with regard to the administrative dismissals? All right. Hearing none, we're going to go on to item number 7. It's the OSA decisions, and we've got one case listed here. It's 21-0020C in the matter of Hardy Davis. Mr. Cusack, it's got your name on here, but does Ms. Young need to comment on this, or? I guess if he leaves anything out, you let us know, how about that? Mr. Cusack, go ahead and proceed with that.
And Commissioners, I just want to start this with, the Office of State Administrative Hearings assessed a $16,900 civil penalty on this case. And I think there's a couple of reasons why this is a good thing, and also sets a good example for our local filers of what they can and can't do. Because this case centers on not only missed personal financial disclosure statements, but missed campaign contribution disclosure reports as part of filing an affidavit saying you will not exceed, or swearing you will not exceed $2,500 in contributions or expenditures. What happened here, and is sort of what some of our fears and what we're trying to get the word out on what not to do and advise candidates who are running for local office what not to do, is what happened in this case. Mr. Davis filed an affidavit saying he would not exceed $2,500 in contributions or expenditures.
What, did you click what office?
Oh yes, he was the mayor. He was a two-term mayor of Augusta. And after entering his, I think the last 2 years of while he was in office, he filed this affidavit in January. Later that same January, we were able to find out through bank records that there was money coming into the campaign and money going out of the campaign exceeding $2,500, and he should have resumed filing right away. What was found ultimately at the Office of State Administrative Hearings in front of the administrative law judge there is that some of these expenditures were not ordinary and necessary expenditures. There was credit cards that were paid off that we still don't know to this day of exactly what was on those credit card statements. There was an ESPN Plus subscription that was being paid for out of campaign funds, a Better Me healthcare subscription being paid for out of campaign funds. And ultimately, the public should have been aware of all this. This should have been showing up in disclosure reports in the filings. There was also contributions, I think over the amount of $10,000, which had come into the campaign during this time. So the public was basically had their eyes, the wool pulled over their eyes on these reports because this affidavit relieved him from filing any disclosure reports. So what has happened now, this judgment was handed down. There is a large civil penalty for this matter, but also I think this serves as a good reminder of when you file this affidavit, you need to keep track of what's going in and out of your account, and if you need to start filing again, you must do so. There were some, I guess, disclosure reports. I think total amount was about 6 to 8 missed. There was 2 personal financial disclosures missed as well. So it's a good decision for us, I believe. This was one that we were talking at our last meeting. I know Ms. Young and I, we knew that decision could be coming any day. And so that leads us sort of into our rule and why we're establishing our rule. And this case was the test run for you as a commissioners, that we got this decision to you within a business day. I think it was the same day we got the decision, made you aware of it, gave you what the advice commission staff had for it, and ultimately sought your guidance on whether we should accept this or sort of let it be. By operation of law, it stands within that 30-day window, or if we needed to bring it in front of the commission for a special meeting to reject or modify. So that would lead us into our next rule, but this case was the test run on that of how that would function in a practical setting.
I think that brings up the issue that I wanted to discuss with regard to the rule, because today, there's nothing for the commission to do with regard to that decision, right?
Correct.
We had to act within the 30 days.
Correct.
Yeah, okay. Mr. Amati?
I'm going to step back for a second and echo something that the chairman said earlier in regards to individuals who are respondents in cases working well with the commission. I think it's worth pointing out is an example of the opposite. Initially, we subpoenaed bank records, and I believe Mr. Davis provided us bank records from 2017 and 2018. And I couldn't locate any other account years. When we then subpoenaed the bank directly, magically a lot of these issues happen to be in the years where those records were not being provided. So I just think I think it's a good point the chairman made. It definitely works the other direction as well when you try and hide evidence or not turn it over in the process.
Any other questions, comments from the commissioners with regard to the decision in the Davis case?
Yeah, I want a quick comment. I'm not going to say I'm correcting you, but I do want to clarify. When you sent this out initially, the request was if you want to have a official open meeting on it, the commission can call that meeting. The commission chose not to proceed, so we didn't advise or respond. We just didn't call a meeting.
Correct, yes, yes.
There was no,
Just letting it become a final order by operation of law
Right.
by taking no action.
right, that's,
Yes.
there was no back chatter on what we should do about it.
Correct.
It was, the commission,
Just
you presented it, we chose not to
Yes.
request a meeting of the chair, and here we are.
Correct, yes.
Yeah, and again, I think that's going to lead right in to our discussion of the next rule. But again, any other questions, comments with regard to the decision of the Davis case? All right. With that being said, we're going to now move into item number 8 on the agenda. And here's the rule for consideration. I don't know if y'all put this on the agenda, in this order for this purpose, but the Davis case certainly provides a good segue into this proposed rule.
Yes, and Mr. McCarter helped me draft this rule as well, so we're batting around ideas of the proper notice of business days. But what this rule is, it's going to be Rule 189-2-.13, and it's the requirement of notice given to commission members by commission staff of initial decision. I'll read the rule and sort of get into the background of why we think this is a good thing. But in accordance with the rules of the State Ethics Commission, Rule 189-2-082, upon the issuance of an initial decision by a hearing officer, the State Ethics Commission shall, within 2 business days of issuance of an initial decision, provide the text of the initial decision to commissioners with a recommendation from commission staff of what action, if any, the commission should take on the initial decision. And I think with our last meeting in Savannah, where we had 2 of these initial decisions, we didn't exactly know what to do or what would happen if there was thought that future commission staff could actually not let you know, say there's an adverse decision and they were embarrassed and they just didn't want to turn over the decision of giving you all notice as commissioners. And so this rule is designed to do that, so that if we're in a situation like we were with the Davis decision and ultimately needed to act quickly, that you as commissioners could call a meeting to act upon that initial decision without that 30 days lapsing and it becoming a final decision by operation of law.
So I guess my biggest question is how is the process going to work? Is it going to be just like what happened in the Davis case, where you're going to go ahead and send that notice out to the commissioners, and then are the commissioners going to get back in touch with with you guys? Do they need to be directing that to the chair, or how are we going to handle that in practice? If there is a real question about what someone wants to do, or what 2 or 3 members of the commission want to do with regard to a decision that's issued.
I think they would have to reach out to the chair to ultimately call the meeting. So I think we would give you the initial decision, and then the call of a special meeting, if there were one to happen, would be through the chair.
The only time we would actually call the meeting, though, it would be something where one of the commissioners, or well, I guess it would be more than one. It would be if the chair called a special meeting for that. But again, how would we handle that? Is that going to be something where we're all coming back up here and we're having to sit down for a meeting? Is it going to be a remote meeting, or how are we going to do that? Is it going to be up to us?
Yeah, I think it'd be up to you guys.
Okay, all right. And we've done that before. We've had questions pop up that have to be addressed, immediately. I can remember the rule changes or the advisory opinions when COVID hit, and that's how we had to do that. It was remotely as well.
Yeah.
Mr. Monteil.
Well, I think the process would be no different than any other meeting where either the chair or 2 commissioners collectively could force that issue and could call for that special meeting.
Do we have any other questions with regard to the proposed rule 189-2-.13?
Who are we going to name it after?
I guess we'll name it after Mr. Cusack, how about that? Cusack. Anything else with regard to the proposed rule? All right, do we have a motion?
So moved.
We got a motion, any second?
Second.
Got a motion and a second, any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right, so the new rule shall be adopted. We're going to go now to, well, you know what? I need to back up, just to make sure we were okay with regard to that. You know, the public can submit any written comments on that if they choose to do so. Did we have any of those?
We did not.
Okay. And we don't have anyone here today that's wishing to speak with regard to that proposed rule. Okay. I just want to make sure because we would go back and re-vote on that if necessary.
Doug Chalmers' email must have been down that month.
I hope he's not listening.
Gross with Duke basketball.
Right. Okay, we'll move to number 9 on the agenda. We got a report of the executive director that includes a legislative update. Mr. Amati.
Thank you, Mr. Chair. So there are a couple bills floating around. Obviously, we're in the throes of the sprint towards sine die. 8 days to feel like 30. But there are a number of bills out there. I'm just going to put these on the commissioner's radar. That they have varying degrees of likelihood of passage, but these are all at least realistic enough that I want to make you aware. There is in the Senate currently House Bill 986, which deals with artificial intelligence and deepfakes as it relates to elections in Georgia. This is obviously a emerging area of concern in elections, not just across the state, but across the world. There was a particularly troublesome set of AI issues in the presidential election in Turkey last year that really brought a lot of this to the forefront. Obviously, we know there was the robocall in the New Hampshire primary purporting to be the president. So I think the legislature is trying to get ahead of this. And this is a lot of moving parts. The state election board is involved. But effectively, the Ethics Commission would also be involved insofar as if campaigns or independent committees want to use artificial intelligence in a above board way, they can essentially, I believe the current proposal is some sort of water stamp on the actual ad that the commission can authorize that they've been approved to use AI. The idea being if you don't have that, that mark, there's an indication that it's illegitimate and probably for nefarious purposes. And this juggles a lot of First Amendment issues that candidly are outside our wheelhouse. But we are monitoring the deepfake AI bill. We're involved in that. And if that ends up passing, it's something that we'll be working with the election board, potentially the Attorney General's office on as well.
So it says the commission has to create this mark and then distribute the mark to, individuals who want to use it?
More or less. We create a seal that said this is,
Seals.
well, we're back to seals, that's right. Listen, we can just recycle that one as far as I'm concerned. But we would create a seal, a watermark, we'd authorize them to use it, and that would be the public show that this is approved AI, this isn't manufactured to, infringe on somebody's ability, their name, image, likeness, that kind of issue.
So you're going to have to document each one you give out. There would have to be a different seal for each single advertisement that wants to use a different AI, or do we have any idea if it's for, you just give a seal to an independent committee and they can use it at the circus as much as they want?
I think, looking at the text of the bill, I think it would be on an ad-by-ad basis. I don't think we would bless one campaign and they never have to show, this is, but hey, fair questions.
And what's the penalty?
The penalty is, so this bill also deals with criminalizing said behavior. So what penalty will there a criminal? I'm not going to get into that. I believe, I don't know that there was the penalty I know on the FARA, the one I'm going to talk about next, Was there a monetary, I think it's just in line with whatever existing, the first violation is up to 1,000, second up to 10, third up to 25. This next bill I'm going to talk about codifies specific penalties for that.
But, you know, how's it gonna get ahead of what's actually occurring? Because by the time if we file a complaint or a third party files a complaint, I mean, the damage has already been done.
So, part of the language in this bill, and it works hand in hand with another bill that Rick Williams has sponsored that is, I believe, in House Rules at some point this week. It works hand in hand with currently, and this is sort of changed, but currently the state elections board could meet and within 60 days of the election could put out something within 30 days, within that period where most agencies are on ice, like we typically are, they could put out something publicly as a third-party neutral body finding it to be not a legitimate video depicting said candidate.
But that wouldn't come from us, that would come from the state elections board?
Currently, there have been other versions of this bill where we filled that void. So I don't want to overcommit on how it's going to end up, House and have different ideas, but that's where we're at right now.
That's gonna require, and I think this has already been discussed, but I mean, that's gonna require, expanding, I guess the folks that we have, working at the commission, we're gonna have to set up a whole new working area.
Depending on how much of this bill ends up under our wing, absolutely. Another bill, Senate Bill 368, is a Senate bill. It's now in the House. This deals with banning foreign national dollars from being spent in Georgia elections. No Georgia, and that's already the rule at the federal level, but no Georgia campaigns, ICs, PACs could take in money from outside the country. Where we get a little more involved is we would be tasked with the responsibility of housing a database. Similar to the FARA doctrine at the federal level, the Foreign Agent Registration Act. Any foreign body who has a registered agent operating within the state would have to register and disclose that relationship to the State Ethics Commission, similar to the Federal Election Commission at the federal level. So that would be an additional responsibility that we would take on. As far as what manpower, what technology would go into that, we have some ideas, but until we get into it, we just don't know what kind of volume we're looking at. There are two more bills. One will be real brief. That is HB 1039, which is currently still in the House. That's a bill that is passed out of committee, been recommitted, so I don't know what work's being done on it, but it would be a bill that proposes if a social media influencer is posting content and they're paid by a campaign to do so, that there has to be some disclaimer on that social media content that this is, was done at the payment of, so-and-so's campaign for such and such office, any independent committee, etc. That brings us to what began as Senate Bill 528. It has been subbed into 258, SB 258, I believe. 358, SB 358, it is, I believe now waiting on a sub and rules, but this is more of an omnibus sort of regulatory bill. So a few things this would do. Currently by rule, the commission doesn't accept any complaints within 30 days of an election. The idea being we try and remove to what little extent we can being a political football. This bill would actually extend that to 60 days within an election, so a primary or general no complaints would be accepted or drafted that close to an election. The campaign disclosure reporting deadlines would completely change, and they would effectively more or less mirror the federals, which would be quarterly. So there would be no more, well, I have 6 reports in this year, but 2 in this year. And if I lost, I have this report out of office, but if I got beat or I retired, I had a different, everyone would be on the same reporting cycle every year, whether you're running for governor, dog catcher, anything in between. And that's something that a number of legislators have talked to us for years about wanting something a little more consistent. Some other things this bill would do, it would, beginning in 2026, the local filers would come back to the state. And I think you've heard a lot today, and I know several of you have heard a lot over the years of misinformation that local filing officers give candidates. money that local offices aren't turning over to us, they should be, reports they won't turn. So this just removes that barrier, and I think makes a lot of sense for a lot of people. Lobbyist reporting would change. So currently, depending on what type of lobbying a lobbyist does, they could, and many of them are, registered as 5 different types of lobbyists all at once. They're a state lobby, they're a state agency, they're a vendor, they're a local. This would effectively say, look, we're collapsing all that into one report. Lobbyists will file one report once a month, every month, and it'll have everything in it. You won't have any more of this, well, I gotta go look at the vendor lobbying reports for that information, the state for that. It's just all gonna be in one place. I think that makes a lot of good sense for a lot of folks. PACs would, the threshold for a PAC to be registered would lower from 25,000 or more being, doled out in 1 year down to 5,000. So, again, we got to balance First Amendment issues, but I think the idea being we want more transparency, more disclosure with the PACs. And their schedule would change so that they are filing every year concurrent with the candidates until the campaign account or the PAC account is empty, which there's a little bit of a loophole right now that is not always disclosed. But those are the big portions, I think, of the bill of 358. Unless I'm leaving something out, Mr. Cusack.
Yes.
Oh, that's right. So a couple years ago, we changed the enhanced financial disclosure reports. So for anyone, and only anyone running for statewide office on a partisan ticket, they now have to disclose the 5-year look back with their income and where their income came from over that 5 years. This bill would amend that, and some of the complaints we got back after that first go-round were, well, we're kind of approximating this salary, you're asking me to swear, and affirm this is, so what this does is it's saying, okay, those sources of income, instead of telling us it was X dollars and 42 cents, which can be a little impractical, they're now given ranges. So what the specific ranges are.
And this mimics the federal law.
Correct. I think our ranges are actually a little better than theirs. I think they're a little tighter, not quite as broad. But this also would be consistent with federal law. So for each source of income, you could say, okay, well, I had this job in this year. I made less than 1,000, or between 1,000 and 2,500, 25 and 5 grand, 5 grand and 15 grand is a range. 15 and 50,000, 50,000 and 100, 100,000 and $1 million, $1 million and 5, and then anything above 5 million is its own category. Now this doesn't change the fact they do also have to disclose their net worth, which has been in place for a while. But I think this is just a little more practical approach of, all right, we want the best information we can get, but we want it to be accurate, and we don't want to be unreasonable about what we're asking you to know. But those are, I think, the big portions of the bill. I think that one has a pretty good chance of getting through.
Now, is that the current iteration of the proposals Mr. Cusack presented to us in December in
Correct.
Savannah?
And some of what has been in the bill, or maybe in the bill, it's not all just what Mr. Cusack presented, but a lot of what Mr. Cusack talked about were discussions we were having with House and Senate leadership at the time, and a lot of that has made it into this bill. But those are sort of the 4 big legislative packages we're tracking across the board. Obviously, big budget still being negotiated, but I think we're in a pretty good position there.
Is that the only report of the executive director?
That is it. That's the only one. Somewhere Bob Watts is cringing in FOMO.
All right, any questions or comments to the executive director from the commissioners with regard to the legislative issues now pending? All right, we'll go ahead and move then to item number 10 on the agenda, report of the Attorney General's office, and that would be Ms. Young.
Can everybody hear me? Okay. Well, Mr. Cusack's already reported on the Davis case and said everything I would have wanted to say better than I would have said it, so thank you for that. Just a couple of quick reports on 2 cases that we have pending in the 11th Circuit Court of Appeals. We had an oral argument December 13th in the case brought by the Libertarian Party of Georgia and former Lieutenant Governor candidate Ryan Graham, which challenges the Leadership Committee statute. At that hearing, the judges asked a lot of questions about whether or not the appeal was now moot, given the passage of time since the election. About 5 days after the hearing, we received a supplemental briefing order from the court asking for some follow-up briefing on that issue, reflecting some issues that when we first briefed the case quite a long time ago, they wanted to have some updates on how the additional passage of time affected the mootness issue. We submitted those briefs, so that decision is ripe for resolution, and hopefully we'll be able to report on that at one of our next upcoming meetings. There is also an argument scheduled on April 18th in the case that was filed by New Georgia Project challenging the ballot committee statutes and independent committee statutes. That will be argued by our Solicitor General's office during April, and I'll report back after that happens in terms of whether any developments come out of that hearing and when we might expect a ruling.
Will that be at the Russell Building?
I believe so, but I can send you a copy of the calendar with the address on it.
Sure.
That's all I've got, thanks.
Any other questions or comments for Ms. Young? All right, thank you very much, Ms. Young. The next item on the agenda, we actually had listed as executive session. I think that we're going to go ahead and, I'll move to amend the agenda to take public comment before we go into the executive session. So again, that's the motion that I'll make with regard to just changing the order of item 11 and item 12. Do I have a second?
Second.
All right, I got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right. Is there anyone here that has signed up for public comment? No? Is there anyone that is present on Zoom that would like to make any public comment? Is there anyone there? Okay, all right. And that, oh, sure.
So I don't know if this is the right time to bring this up or not. But speaking of Zoom, I would like to formalize something that we stop it and stop allowing participants to actually participate. I don't mind people listening, but having these Zoom calls is taking too much time. It doesn't seem to be, very well, not that it's not well organized, but it's just not being executed. So I don't know what we have to do. I don't know why we're still doing it, but.
I'll just tell you that I am in perfect agreement with that. I think all of you probably know that I'm probably the greatest infant up here when it comes to technology. So, again, I would be, all in favor of doing that. Otherwise we're going to have to really, nail down on what we're going to be doing with Zoom. I think this is right with what Commissioner Thompson was saying is, at the beginning of every meeting, there's always something that happens with technology. I'm not offering any criticism necessarily with regard to our staff. I'm just saying that is something that we've got to nail down and move forward with. I don't think that that's actually anything that would require any type of vote of the commission. Y'all can tell me otherwise, but I believe it's a staff issue, at this point. And, again, Commissioner Thompson's in favor of this. I am certainly in favor of, there being any issue where someone wants to speak where they're actually here at the commission. That's the way that it used to be. And, I think it's time to go back to a lot of things with regard to the way that things used to be. So, anyway, that's sort of our message, I guess, to the commission staff. And certainly, you have to do something on the website to make sure that everyone is aware of that. when any notices go out with respect to the next meeting, I think I would put some, bold star or something like that, that, when we send those notices, that, there's no question that people have gotten, notice of the fact that they have to be here as opposed to participate, through Zoom. So, does anyone else have any issues on that? Look, I appreciate you bringing that up. I think that's a great point. So I guess we can consider that Commissioner Thompson's public comment.
The Thompson rule.
There you go. Man, I'm gonna have so many of these things now, I'm not even gonna be able to keep them straight. It was always, when Jake Evans was the chair, he always wanted to do some kind of vote with respect to the administrative dismissals. And, I got to sit right beside him, so I got to look at him every time and say, we don't do anything. So, all right, we're gonna go back to what is actually item 12 now. It's gonna be executive session. It looks like it's on here in order for the commission to discuss legal matters. I'll go ahead and make the motion that we enter executive session. Do I have a second?
Second.
I got a motion and a second. Any comment? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, we'll be in executive session, and then we will come back and adjourn the meeting. But if there's any necessary, point that we need to put on there with regard to making a vote with respect to anything discussed in executive session, you know what? I don't know. We'll talk about that because I'm not sure that we've given 24-hour notice with regard to that. But I'll think about that before we come back into session. Anybody have a question?
Yeah, where we going?
Oh, yeah, I don't know.
Line 14.
We'll go ahead.
We're live.
All right, I'm going to call the meeting back to order. We just left executive session, so I'm going to go ahead and make a motion that we end the executive session. Do I have a total? Do I have a second?
Second.
I got a motion and a second. Any discussion? All right, hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, so we're back in regular session, and I think the only thing that we have left is to adjourn the meeting. Is that right? All right. I got a second. Any discussion? All in favor say aye.
Aye.
Thank you.